Share my screen. Okay, minimize you guys. So I'm no longer seeing you. So if you have any question, just speak out because I won't see any hand raising or if you look confused or anything. So we'll start on page 45. So if we remember, the listing agreement is the same listing agreement for Maryland and DC with regards especially to Montgomery County. When you go outside of Montgomery County, through your portals, you might find another listing agreement or certainly a different jurisdictional agreement. So right now we have a jurisdictional agreement that's for Montgomery County. It is required to go along with your listing agreement. So whereas compared to Virginia, the listing agreement seems to be a little bit less detailed, we actually get in more of the weeds and the details here in this document. So starting on page 45. So the listing agreement, so the date should match the date of your listing agreement dated between the seller and the broker and the property. Okay, that's all standard. You guys have been doing this and know what to do there. So it defines agency right up front in Maryland. So agency, disclosure, and consent for dual agency. Seller acknowledges that the broker has informed seller of his rights and obligations as defined in consent for dual agency. So there's an addendum for that, and that's part of your package. And then ministerial acts. Seller agrees that the agent may perform ministerial acts for a buyer. A ministerial act is an act where the agent assists the buyer to complete or fulfill a sales contract with the seller, and an act that does not involve discretion or the exercise of agent's own judgment. So that would be a situation where someone, and you see it more probably in leases than you do in contracts, but normally it's where, like in a lease situation, someone comes, they're not represented, you have them sign the document to state that they're not represented by you, and then you are going to help them fill out their application, turn in their paperwork. You're not advising them in any way, shape, or form. And that's what a ministerial act is. You're not advising them, and you're not using your own judgment. You're just facilitating paperwork. So if a person came without an agent, you could do a ministerial act of facilitating writing an offer for them, but you're not doing dual agency. But that's a risky proposition. I would say refer it on to somebody else. So fair housing. Seller acknowledges that Montgomery County and the state of Maryland require that the property shall be made available to all persons without regard to race, color, religious creed, ancestry, national origin, sex, marital status, disability, presence of children, family responsibilities, sexual orientation, source of income, age, or gender identity. Okay. I think we all understand fair housing, but it's worth repeating. Transfer and recordation fees. There are 3 taxes payable in Montgomery County when a deed is recorded: the state recordation tax, the state transfer tax, and the Montgomery County transfer tax. Maryland law requires that the cost of these 3 taxes shall be paid as follows. If buyer is not a first-time Maryland home buyer, there's an asterisk there. So we got to wait to see what that means. And down below, you'll see right here where the asterisk follows. So that's where you read down to. Under Maryland Code 14-104, a first-time Maryland home buyer is defined as an individual who has never owned a residential property in the state of Maryland that has been the individual's principal residence, and the residence being purchased will be occupied by the home buyer as their principal residence, okay, who has never owned. Now, in lender circles, they say first-time home buyers is someone who hasn't owned in 3 years. So in Maryland, it's saying that they've never owned a home as an individual who has never owned a residential property, okay? So bear that in mind. Then such state taxes shall be shared equally between the seller and the buyer unless otherwise negotiated in the sales contract. So if buyer is a first-time Maryland home buyer, so same asterisk, then all the transfer and recordation taxes shall be paid by the seller unless otherwise negotiated in the sales contract. C, if buyer is a first-time Maryland home buyer, asterisk, Maryland law states that the rate of the state transfer tax is reduced to 1/4% of the sales price and shall be paid by the seller. So B and C could apply here. So the state transfer tax is reduced for a first-time home buyer and shall be paid by the seller. Now this one does not say negotiated. This one can be negotiated. And where these two get negotiated, in my experience, is in a seller's market. The buyer may choose to pay the fee themselves and instead of passing along to the seller, hopefully that the seller will take their offer, okay? But in this one, it says, shall be paid by the seller. It means the seller has to pay it when it's being reduced to 1/4%, okay? All right, so Maryland non-resident seller transfer withholding tax disclosure. Seller acknowledges pursuant to the Maryland Code 10-912 of the State Property Article and Annotated Code of Maryland that if a seller is a non-resident individual of the state of Maryland, or, so this is an or proposition, this is where we want to always keep an eye on these things, and they're nice enough to us to highlight them. So it's one or the other applies, okay? Or a non-resident entity which is not formed under the laws of the state of Maryland and is not qualified or registered with the State Department of Assessments and Taxation to do business in the state of Maryland. The deed or other instrument of writing that affects a change of ownership to the property may not be recorded with the clerk of the court for the county or filed with the Maryland State Department of Assessments and Taxation, I'm sorry, having a hard time today, unless payment is first made by the seller in the amount equal to 8% of the total payment to the non-resident individual seller, or 8.25% of the total payment to a non-resident entity seller, okay? So you've got two things to consider there. Unless seller certifies in writing under the penalty of perjury that the seller is a resident of the state of Maryland or is a resident entity of the state of Maryland. Entity meaning a business, okay? Now, we as agents are not responsible, if you will. We have to share this information with our clients, you know, and they declare. We're not going to judge them. You know, they're the ones who have to declare what they're going to declare. We make sure they read this and understand and choose accordingly. Okay. So up here under unless, see, we're following over to the next page. We got paragraph 1 and paragraph 2. We got an or statement there. Presents to the clerk of the circuit court for the County of Maryland State Department of Assessments and Taxation a certificate issued by the comptroller of the state of Maryland stating that there is no tax due in connection with the sale or exchange of property, or a reduced amount of tax is due from the seller, and the reduced amount is collected by the clerk of the circuit court for the county or the Maryland Department of Assessments and Taxation before recording or filing. Note, if the seller intends to obtain the certification from the comptroller's office, seller should immediately contact the comptroller. Obtaining the certification required. Okay, requires a minimum of at least 3 weeks. Now in COVID, you know it's going to be more than that. Okay, so breaking up the paragraphs. Okay, so here you've got paragraph B, and it breaks down into these two sections. Now we've got C. So C does not follow along with what we just read. Always pay attention to your paragraph headings. Has satisfied the tax liability or has provided adequate security to cover such liability. Certifies in writing under the penalties of perjury that the property is being transferred for the seller's principal residence. Okay. As defined under the Maryland law and as used in and above, the term total payment means that the net proceeds paid to the seller for the property and associated tangible personal property, less the debts owed to the seller and secured by a mortgage or other liens against the property being paid upon the sale or exchange of the property, and other expenses of the seller arising out of the sale of or exchange of the property and disclosed on a settlement statement prepared in connection with the sale or exchange of the property. The total payment includes the fair market value of the property transferred to the seller. All right, so we're going back up, and this is regarding Maryland non-resident seller transfer withholding tax disclosure. So as you're reading down through here, you know, you kind of get lost in the weeds as to what's going on. So as a non-resident Maryland seller, then they have to acknowledge and choose which one of these categories they're going to purchase under and what they need to supply to the title company, okay? Now we're at receipt of information and completion of disclosures. I'm so sorry. I have a sinus infection. And it's just like, well, I don't wear glasses, and when I have a sinus infection, my eyes tend to get foggy a little bit. So that's kind of where I'm at today, unfortunately. So bear with me. I apologize. Receipts of information and completion of disclosure. Seller acknowledges seller's receipts and or completion of the following disclosures as applicable and authorizes broker to make them available to prospective purchasers. So these are the disclosures that you as good full-time agents are going to put on the MLS under that documents category. There's nothing worse than getting ready to make an offer, especially a Maryland offer or a DC offer, and the disclosures are not there. And then you have to wait for them to be sent to you, especially in this fast-moving market. Okay. So the Maryland Residential Property Disclosure or Disclaimer Statement, Form 112. The lead-based paint federal disclosure. The lead-based paint federal disclosure and hazard for rentals. So you got the sales and the rentals. Maryland lead-based paint prevention program, because Maryland has their own you have to fill out. The REA, which I asked you guys to glance at this last week just to see what all it entails. The inclusions and exclusions, disclosures or addendum. Now that is what we normally have in Virginia in our listing, you know, what conveys, what doesn't. The NAR pamphlet, what everyone should know about equal housing opportunity. So you have to provide that. Okay. Open house. During an open house, seller gives consent to broker and licensees thereof to discuss other properties unless otherwise specified here. So if there's a house up the street that the buyer comes in and you're holding an open house, whether you're the listing agent there or not, you represent the seller, right? And so here, unless you otherwise specify, if someone comes in and says, can you tell me about the house up the street? First thing you ask them, do you have an agent? If not, then I would make them sign some document that you're going to assist them before you give them too much information about the house up the street. But this is allowing you, while on someone else's premises at an open house, to discuss another property, okay? Because normally that's a no-no. In Virginia, you teach that that's a no-no because you're there to represent the seller and the seller's interest. Okay. So home security systems that monitor or record audio. Sellers advise that Maryland has a law prohibits audio recording and or monitoring of private conversations without the consent of all parties. So if they do have an audio recording and they want it on during an open house or at all times, then the people coming through must sign an agreement stating that that's okay. Okay. So that means the seller can't leave it on at all times unless there's a provision set in place for an agreement to be signed. Okay. Offer presentation. All written offers or counter offers shall be presented to the seller in full as a hard copy or in electronic format unless otherwise specified here. Okay. Now, if there's no specification like on 6 or 8 or any other paragraph, I would go ahead and just put an NA in there. It makes it clean. Don't just do a dash mark. People aren't sure what that is when it gets copied over. But an NA lets them know that you've discussed the paragraph and it's not applicable to them. Okay, that's keeping it clean. Termination. A, the broker's relationship established by this agreement may be terminated unilaterally by either party prior to the ending of the listing period by either party delivering blank days advance notice to the other. That's a choice. It's a discussion between the parties. 1, 2, 3 days notice, whatever it is. I tend to like 3 days because when you got the weekend in there, stuff like that. But unilaterally means that you as the broker can fire the seller can fire the broker. We don't have to agree upon it. It's a unilateral notice. But again, you can choose how many days. The more days for the broker, the better. The fewer days for the seller, the better. Kind of think about it like that. Okay, even if the broker's relationship is terminated under the terms above, the contractual obligation shall remain in full force and effect unless terminated by mutual consent of all parties. Okay, so now it's telling you up above that you can unilaterally fire one another, but now it's telling you, but you have to be terminated by mutual consent, which for me is a bit confusing. It's either or not, but we'll continue reading here. Shall remain in full force and effect unless terminated by mutual consent of all parties. In addition, the terms of the GCAR listing agreement, paragraph 7A2, or the MR listing paragraph 14 protection period shall survive even if the agreement is terminated early. Okay. So when we go to paragraph 7A2, and so that's basically that it says it further, such broker's fee shall be paid if the property is sold, engaged, conveyed, or otherwise transferred within X amount of days. So say within 30 days after the expiration of the listing period or termination of this agreement, which is known as the protection period, to anyone to whom the property has been shown by the broker or anyone else, including the seller, during the listing period, unless a valid list agreement is entered into during the term of said protection period with another licensed real estate broker. So basically, your client has fired you. You've agreed to it. There's been a termination. They haven't engaged anybody else. And 15 days later, someone comes up and calls you and says, you were the listing agent on the property. I have clients that are interested in it. Can you tell me about what's going on? Whatever. And then you, under paragraph 7, A2, you're covered to receive commission there if that seller has not engaged in another listing agreement. Okay. But generally speaking, when someone fires you, they're already getting someone in the wings. Someone's there ready to take over because, they don't like what you're doing or they don't trust you anymore, whatever the situation is. Okay. So the Maryland jurisdictional agreement, it's 2 more pages onto your listing agreement. Okay. Now, if you notice here, the listing agent signs. The broker certainly signs, but the listing agent also signs. So you're, along with your broker, you're in agreement with what's being said and stated above. Now, this document is mandatory in Maryland, and you have to have it printed in color as it is here. Okay. Attention prospective purchasers, please read this sign carefully. This is to advise you that the agent who is conducting this open house represents the seller and is required by law to promote the interest of the seller. Any information you give this agent is not considered confidential under the Virginia Real Estate Brokers Act and could be disclosed to the seller of the property. You as a buyer are entitled to have someone represent you as the buyer's agent if you are interested in this property. The duties of a buyer's agent including helping you to evaluate the property, prepare an offer on the property, and negotiate in your best interest. So when you're holding an open house in Maryland, you need to print this out. And I've seen people post it on the door. They put it in a sleeve, and then they usually have it in the house at least one other place. But you want to make sure that it's noticeable, that if someone from Maryland was walking through your open house, they're going to easily see it, and you're not going to get in trouble for not having it. Okay. So State of Maryland Real Estate Commission consent for dual agency. So in this form, the word seller includes landlord, buyer includes tenant, and purchaser or sale includes the lease. So it's for both sell and lease, okay? And without having two separate documents defining it for the same purpose. So when dual agency may occur, the possibility of dual agency arises when the buyer is interested in a property listed by a real estate broker and the seller's agent and the buyer's agent are affiliated with the same real estate broker, okay? So unlike what we think of dual agency is I'm representing the buyer and seller, me solely as an agent. In Maryland, dual agency is truly what dual agency means. It's when agents within the same brokerage represent both parties in a purchase and sale of a home, okay? So bear in mind, in Maryland, I as an individual agent cannot do dual agency, but the broker can be a dual agent, okay? Important considerations before making a decision about dual agency. A broker or broker's designee, I would be a designee, acting as a dual agent does not exclusively represent either the buyer or the seller. There may be a conflict of interest because the interest of the seller and buyer may be different or adverse. As a dual agent, the real estate broker does not owe you undivided loyalty to either the seller or the buyer. Before the buyer and seller can proceed to be represented by a broker acting as dual agent, they both must sign the consent for dual agency. If the buyer has previously signed consent for dual agency, the buyer must affirm the buyer's consent for the purchase of a particular property before an offer to purchase is presented to the seller. If seller has previously signed consent for dual agency, the seller must affirm the seller's consent for the sale of the property to a particular buyer before accepting the offer to purchase the property. The affirmation is contained on page 2 of this form, okay? Your choices concerning dual agency. In a possible dual agency situation, the buyer and seller have the following options. Consent in writing to dual agency. If all parties consent in writing, the real estate broker or the broker's designee, the dual agent, shall assign one real estate agent affiliated with the broker to represent the seller's intercompany agent, and another agent affiliated with the broker as the buyer's intercompany agent. So for those who are familiar with Virginia, this is like designated agency, the way we look at it in Virginia, okay? Intercompany agents are required to provide the same services to their clients that agents provide in transactions not involving dual agencies, including advising their client as to price and negotiations. So if Rebecca and I are having a deal together, I have a listing in Maryland. She brings the buyer. We have to do the dual agency. Because we're from the same brokerage, in the consumer's mind, we can be in cahoots trying to form a deal that could harm either one. But in reality, that's not what goes on. I'm sure in some, excuse me, in some companies it may, but we're not, I'm not going to tell her what my client's lowball offer is, what they'll accept. But you have to, the public has to be aware and agree to what you're doing. So if something does go awry, you have their consent that they knew that we work for the same brokerage, Keller Williams Realty or Keller Williams United, as we will soon be. Falls Church, Old Town or Kingstown, and the like. Okay, refuse to consent to dual agency. If either party refuses to consent in writing to dual agency, the real estate broker must terminate the brokerage relationship for that particular property with the buyer, the seller, or both. If the seller terminates the brokerage agreement, the seller must then either represent him or herself to arrange to be arranged or represented by another real estate company. So basically, you would be saying to your buyer, if you don't consent to dual agency, then any listing that our 3 offices have, you have no access to. So again, it's like in Virginia, it's like designated. So if you're familiar with Virginia, think about it along that track. Okay. So if the buyer terminates the brokerage agreement, the buyer may choose not to be represented, but simply to receive assistance from the seller's agent, from another agent in that company, or from a sub-agent from another company. Alternatively, the buyer may choose to enter into a written buyer agency agreement with a different brokerage or company. Yes.
Does this mean that if there's a listing from our Kingstown office or wherever the other one is, that is dual agency?
Yes, because Steve's a principal broker.
How does that work if there's like a lawsuit if one of the prices then sue? Well, is that why this is such a big issue? Steve would be
Yes, yeah. I'll confirm with Shannon, but that's my understanding how we're doing it because we're all under one brokerage. And it would just be, I know in Virginia, we've been advised to do that. And I would think Maryland and DC as well. Yeah. Because if someone were to look at it, you've got the same principal broker, especially becoming KW United, but it's always better to err on the side of caution. Yeah. So when they sue, one party sues another party, that's why we have E&O insurance, for one thing, and errors and omissions insurance. But just like in a divorce situation, you have your own attorneys and stuff, So each as individual agents, you have your errors and omission policy. But we're doing everything we can not to get into court. Yeah. All right. So duties of a dual agent and an intra-company agent. Like other agents, unless the client gives consent to disclose the information, dual agents and intra-company agents may keep confidential information about a client's bargaining position or motivation. For example, without written consent of the client, a dual agent or intercompany agent may not disclose to the other party or the other party's agent, what I just kind of said a minute ago, anything the client asks to be kept confidential. Okay, then there's an asterisk, go down where the asterisk is. Dual agent and intercompany agents must disclose material facts about a property to all parties. So that's your caveat there. No matter what side of the coin you're on, if there is a material defect or a latent defect, you have to disclose it as an agent. You have knowledge of it, you have to disclose it, okay? That the seller would accept a lower price, we don't disclose that, okay? That the buyer would accept a higher price. The reasons why a party wants to sell or buy, or that a party needs to sell or buy quickly, or anything that relates to the negotiation strategy of a party. Now, sometimes you can ask, and I did that yesterday. My potential buyer wanted to know why they were selling their home. They'd only been there for 2 years. And the agent was able, you know, she was able to share. Now, had she not been able to share, that would have been the end of the story. But they were able to share what they were doing. Because when your client asks you, don't take it on yourself to say, oh, we can't ask that question, because the seller may have given the other agent permission to answer that question. So you can always say, I always say to the other agent, hey, I've got this question from my client. I know it's a bit unusual, but if your client feels comfortable answering it, do you mind? And most of the time they do answer it or give a satisfactory enough answer. So like in the case yesterday for me, that property was less than 2 years old and they were selling. So it's like, so the buyer was afraid that something was wrong, it's just that they got orders to move. So that, things like that. So consent for dual agency. Okay. So remember, we're on page 2 now, because it says above on page 2, they're going to give consent. Okay, I'm sorry, back up. How dual agents are paid. Only the broker receives compensation on the sale of the property listed by the broker. If a financial bonus is offered to an agent who sells a property that is listed with his or her broker, the fact must be disclosed in writing to both the buyer and seller. Okay. You often see bonuses when it's a buyer's market. We don't see a lot of bonuses in a seller's market to get the house sold. But the bonus would be the selling agent's bonus if there's one offered. Okay. Consent for dual agency. I have read the above information and I understand the terms of the dual agency. I understand that I do not have to consent to dual agency, and that if I refuse to consent, there will not be dual agency, and that I may withdraw my consent at any time upon notice of the dual agency. I hereby consent to have Keller Williams Realty Falls Church right now, and whatever our broker's name will be later on, as a dual agent for me, so if I'm the listing agent, my seller's going to say as a seller for the property, blah, blah, blah. Because remember, it's not me who's representing the buyer and seller, it's the company. So as the listing agent, I've had my seller fill this out. You as the selling agent or buyer's agent, your buyer has filled this out. And then you come together on a property, and that's where the affirmation comes in down below. Okay, so down below it says the undersigned buyer hereby affirms consent to the dual agency for the property above, and then the information, the undersigned seller hereby consents. So they've independently signed an agreement for dual agency, and then once they're consummating that relationship in the offer stage, not the ratification stage, but in the offer stage, that's when this gets signed, during the offer, okay? And it would behoove you as agents to also mention to, because you're gonna have them affirm it, because you're saying, I just want you to know that this listing agent is in our brokerage, which, as we understand in Maryland, that's considered dual agency. And you just give them confirmation and assurance that you represent them fully as their agent, and that you're not sharing information over the water cooler or through a Zoom chat nowadays with the other agent, okay? So inclusions, exclusions, okay, this is required for the use for the GCAR listing and sales contract. So what this means is you as a listing agent, you have to have your client fill this out, and then it becomes part of the sales contract that you upload online, okay? So the personal property feature, so this is different than the Virginia one. It looks different in some respects. So you're not having a yes or no. So it's a check mark for a yes only. So the property includes the following personal property and fixtures, if existing: built-in heating and central air conditioning equipment, plumbing and lighting fixtures, sump pump, attic and exhaust fans, storm windows, storm doors, screens, installed wall-to-wall carpeting, window shades, blinds, window treatments, hardware, mounting brackets for electronic components, smoke and heat detectors, TV antennas, exterior trees and shrubs, unless otherwise agreed upon to herein. All surface or wall-mounted electronic components, devices do not convey. Okay, so it says, unless otherwise agreed upon herein, All surface or wall-mounted electronic component devices do not convey. Okay. Items checked below convey. If more than one of them convey, then put the number next to it. I want to back up about shrubbery. One of the agents in our office years ago was in helped a buyer buy property, and the seller actually took some of their trees away, had them dug up and moved. So you as a listing agent, things like that, you know, when you're going over your agreements with your clients, and I had another situation where they took the storm door. They had a decorative storm door that was handmade for them. Okay, so there again, when you're doing your listing appointments, you know, when you see personalized things, you might suggest they have those removed and something else put in place, but they can't just arbitrarily take the storm door when they leave, okay? So now you've got your appliances in range. So I'm finding more and more lately that a lot of agents are really kind of messing up their stoves, okay? So I had to have a conversation the other day with someone, and because their pictures, I was helping someone write an offer, and it was a Maryland offer, and it said stove and range. It had cooktop and wall oven, which could be possible. I have been in a kitchen that has had all three, but their pictures were not very clear. Their pictures were not good pictures where I could not tell in the picture if that was in fact what was there. So I called the agent and she was like, well, everything's listed online. I'm like, I know, but you have a stove and a range, a cooktop and a wall oven. She goes, well, there's no stove. I said, okay, so you're just talking about a cooktop and then a wall oven, and you have two wall ovens, right? Yes. Well, why do you keep asking about the stove? It's like, because it's checked. So what happens in Maryland is that the clients have to fill this out. You as agents cannot fill this out. It doesn't even allow you to check it when you're in DocuSign. So what happens is, unless you as a listing agent has set with your clients to walk through this, they may inadvertently check something that they don't realize, you know. So a stove and a range is a freestanding device. So there could be a stove and a range and a cooktop and a wall unit. It might be someone who's is fond of cooking, okay? So then you've got refrigerators, ice makers, wine refrigerators, you know. Again, in Maryland, if it's more than one, like there could be a refrigerator in the garage or the basement they want to convey, then you would put two there. But if only one has an ice maker, then it would be two refrigerators, but one with an ice maker, okay? And then, you know, the items that are here is what you're going to find in MLS. The other thing we don't have in Virginia that I see, a couple things over on the other that we don't, in Virginia, we have storage shed. We do the garage door openers and the fobs. We don't have backup generators, radon remediation, or solar panels. Okay, so those are some other things to look at. Now, I would encourage you, when you're talking to your clients as listing agents, and I know David Robertson has talked about this, where one of our beloved agents had to buy garage door openers because they had her client had three garage doors, and she put down three garage door openers when in fact they had none because all their cars had the devices in their car. So there were no actual garage door openers. So when you talk to your clients and filling out paperwork, make sure it's a physical remote or a fob for the garage door or some type of opener, okay? Let's see. So then if there's exclusions, so if there's an exclusion of something above, then make sure you have it listed there. Again, it's your seller who has to fill this stuff out. You cannot fill it out yourself. It doesn't allow you to click the boxes, but you as a listing agent, full service agent, should be sitting with your client, or at least on a Zoom call with them or on the phone with them, with you having the document up, walking through with them, okay? And making sure they're filling out the right information. Okay, leased items and leased systems and service contracts. A leased item or system or service contract, including but not limited to solar panels and systems, appliances, fuel tanks, water treatment systems, line contracts, security systems, and or monitoring and satellite contracts do not convey it unless otherwise disclosed. Because those systems, there's usually a contract for services, okay? And in the system, water treatment system, like propane tanks could be above ground, underneath ground. The seller could own the tank, but they purchase the gas, or they could be leasing the tank and purchasing the gas. So you need to find out from them, if there's any such systems. And like alarm systems, we say alarm system conveys. Well, it's not the alarm system that conveys, it's the hardware in the home that conveys. It's a separate agreement that they get in later on with that particular alarm company. Certification, seller certifies that the seller has completed this checklist, disclosing what conveys with the property. So right there, it tells you the seller has to complete this and they have to certify that they did, okay? So if it was the agent and they didn't fill out something right and it goes to court and the judge says, well, Mr. Seller, did you or did you not fill this out yourself? You certified that you did, So, and then, in that situation, the agent and the seller both would be culpable. Okay, so acknowledgement and incorporation into contract, completed only after the presentation to the buyer. So this paragraph, and it's another reason why you want to make sure you're sitting with your clients, because you do not want them signing here. This only gets signed after an offer comes in, okay? So what happens is the buyer's agent pulls this down from the MLS, and then in DocuSign, or if they have an Adobe package or some online PDF filler in, they put in the date of the offer, they put in the seller's names, they put in the buyer's names, okay? And then the buyer signs, and then the seller signs. It says right there, signs only after the buyer. I have downloaded numerous of these online where the seller has already signed, okay? So Maryland residential property disclosure and disclaimer statement. Property address, legal description. Where do you get the legal description? From the tax record, okay? Some tax records will have the word legal description or legal DESC sometimes. If not, put as much information as you can in there. Block, lot, whatever. Just identify that more than just a property address. And I encourage you to do this for so many reasons, because places that could have been apartments before they got converted to condos. So it may have been 1234 Main Street, which is a block of apartments. And then you had, apartment 1, 2, 3, 4, or 100, 100, 102. But then when they became condos, they gave them a different number, okay? But in the basic tax record, the tax record still has the original description. And that's part of the deed, that's part what transfers with it. And I have run into that in Fairfax. And it was a rental situation, but we got there in the lockbox. We couldn't find the apartment number because it's at apartment 28, but it was really apartment 302. It was the only one of 6 units in this place that had a lockbox on it. But that's because it had been converted. So, and they just changed the numbers for the post office, but it was not changed in the tax record, okay? So be careful about that. Notice the seller and purchaser. Section 10702 of the real estate article annotated Code of Maryland requires that the seller of certain residential property to furnish to the purchaser either a residential property disclosure statement stating that the seller is selling the property as is and makes no representation or warranties as to the condition of the property or any improvements of the real property except as otherwise provided in the sales contract or the listing of latent defects, or a residential property disclosure statement disclosing defects or other information about the condition of the real estate actually known by the seller. Certain transfers of residential property are excluded from the requirements See the exemption list below. So again, this is an or proposition. It's either A or B. Don't have your seller fill out both. It's A or B. They're either saying it's as is, or they're going to make their disclosures, okay? They have to make the decision which they're going to do with your counsel, okay? So the following are specifically excluded from the provision. The initial sale of a single-family real estate property. So the initial sale of a single residential real estate property that has never been occupied, i.e. new construction, for which a certificate of occupancy has been issued less than 1 year before the seller and buyer enter into a contract of sale. So because the seller has nothing to disclose, a new construction, they've never lived in the property. Therefore, there is no knowledge of anything that could be a problem, okay? So they're excluded from having to do this form. A transfer that is exempt from the transfer tax under the tax code article except land installment contracts of sales under the of the tax property article and options to purchase the real estate under a tax property article. Transfer that is exempt from the transfer tax. So something sold for taxes. A sale by a lender or an affiliate or subsidiary of a lender that acquired the property by foreclosure or deed in lieu of foreclosure. A sheriff's sale, a tax sale, or any sale by foreclosure, partition, or by court-appointed trustee. A transfer by fiduciary in the course of administration of a decedent's estate, someone who's passed away, guardianship, conservatorship, or a trust. So someone who is a trustee or guardianship, administer for an estate, they don't know anything about the property, therefore they don't have to disclose anything about the property. So they are exempt and excluded from this provision, okay? A transfer of a single family resident real estate property to be converted by the buyer into use other than the residence use or to be demolished. So if you're selling a property that's going to be torn down, then you're exempt. You're listed as that. You're listing a piece of land that has a structure on it. Therefore, you don't have to have this document because you expect them to demolish it. A sale of unimproved real property, which is land. Unimproved real property, which means there's a parcel of property that there's nothing on it that's improved it other than the land itself, okay? Okay, with that, let's take a break until 1 o'clock, okay? Give everybody time to stretch. Give me a time to stretch. Stop sharing my screen. Pause. Back on to record. Back to sharing my screen. Okay. Is the screen up? Let's see. Everybody's. Can someone unmute and tell me if the screen is showing? Anyone out there?
Yes, it is.
Okay, thank you. Do you want to be talking to myself now? I guess it's recording, so I can talk to myself and people can watch it later. Rebecca's here keeping me company. Us in this huge room, we're definitely social distancing. We're like 30 feet apart or something. Okay. So, so again, you've got your exemptions above there. And now we're going down to what the disclosure statement actually says and what the seller has to fill out. So notice to the sellers, complete and sign this statement only if you elect to disclose defects, including latent defects or other information about the condition of the property actually known by you. Otherwise, sign the residential property disclosure statement. So disclaimer, so you've got disclosure, disclaimer, okay? In Virginia, we kind of tend to say both things, but in Maryland, they separate it. So you're going to disclose something or you're going to disclaim. You may wish to obtain professional advice or inspections of the property. However, you are not required to undertake or provide any independent investigation or inspection of the property in order to make the disclosure set forth below. The disclosure is based on your personal knowledge of the conditions of the property in the time of signing of this statement. Notice to purchasers, the information provided in this representation of the sellers and is based upon the actual knowledge of the sellers as of the dates. I'm sorry, I can't read. The date noted. Disclosures by the seller is not a substitute for an inspection by an independent home inspection company, and you may wish to obtain such inspections. The information contained in this statement is not a warranty by the seller as to the condition of the property of which the seller had no knowledge or other conditions of which the seller had no actual knowledge. So then if your seller wants to provide this information, they can. How long have you owned the property? What are your systems? Check all that apply, okay? Please indicate your actual knowledge with respect to the following. The foundation, any settlement, yes, no, or unknown. Basement, roof. Again, it's your seller who has to go down through all of these things and check on them, okay? You as agents cannot, it doesn't allow you online to do it. So you'll often see this as a handwritten document. Sometimes I'm suspicious when I see that it's typed, but, or, electronic printed, but like myself, others may have an Adobe and they choose to be neat about it. So I don't always think that the agent's done it by a trick, but I'm always curious when I see it because most of the time it's handwritten. 8A, will the smoke alarms provide an alarm in the event of power outage? Yes or no? Are the smoke alarms over 10 years old? Yes or no? If the smoke alarms are battery operated, are they sealed, tamper resistant units incorporating a silent hush button, which use lifelong batteries as required by all homes in Maryland since 2018? Yes or no? And you may or may not know about smoke detectors. Their life is really not much more than 10 years. So if, as a listing agent, if you've got a client who says, yeah, they're probably 8 or 9 years old, you might consider just having them replaced before you put the house on the market, because they will go out during an open house and they will continue to chirp, okay? It just happens. Okay, septic systems. Is the septic system functioning properly? Yes, no. Water supply, insulation, exterior damage, wood destroying insects. Remember, it's your seller who's opting to fill this section out. And once they start opting to fill it out, they have to answer yes, no, comments for every single item here, okay? 16, if you or a contractor have made improvements to the property, did they require a permit pulled by the county or local permitting office? Yes or no? So you as an agent are not guessing if that additional in the back was permitted or not. The seller is going to identify here yes or no, okay? So down below, note, seller may wish to disclose the condition of other buildings on the property on a separate residential disclosure. Okay, so if there's a, exterior garage or a shed or whatever, okay? So that's page 3 of 4. Now here the purchasers are so the seller is going to fill that out and then the purchasers are going to acknowledge it. Or the seller is going to completely ignore that first section, and then they're going to say, they're going to do this section. Notice the sellers. Sign this statement only if you elect to sell the property without representations and warranties as to the condition except as otherwise provided in the contract of sale and in the listing of latent defects set forth below. Otherwise, complete and sign the residential disclosure property. So you say to the seller, sign this statement only if you elect to sell the property without representations and warranties as to the condition, except as otherwise provided in the contract of sale and in the listing of latent defects set forth below. Okay? Except for the latent defects listed below, the undersigned seller of the real property make no representations or warranties as to the condition of the real property or any improvements thereon, and the purchaser will be receiving the real property as is, with all defects, including latent defects, which may exist except as otherwise provided in the real estate contract of sale. The seller acknowledges having carefully examined this statement and further acknowledge that they have been informed of their rights and obligations under Code 10-702 of the Maryland Real Estate Property Article. Okay? Section 1-702 also requires the seller to disclose information about latent defects in the property that the seller has actual knowledge of. The seller must provide this information even if selling the property as is. Latent defects as defined as the material defects in the property. A purchaser would not reasonably be expected to ascertain or observe, be careful and visual inspection of the property, and would pose a direct threat to the health and safety of a purchaser or occupants of the real property. Seller has knowledge of latent defects, yes or no? If yes, specified. Then the seller signs and the purchaser signs. So in reality, this section, in my belief, is kind of more like the Virginia buyer beware. You know, in Virginia, it says that we're selling the property as is unless noted otherwise. And then the buyer hires a home inspector and you move forward. So as a listing agent, it's much simpler for your client to sign the second half, the disclaimer, instead of the disclosure, but it's up to them how they want to present the offer.
Why would you ever do it the other way?
Why would you do the first one?
Yeah.
I don't know, because, you know, I'm a Virginia agent before the other, and I'm used to this language more so. And, but ironically enough, on all the contracts I've written for Maryland over the years, I find I have this section filled out more. I don't know that agents feel that their clients are more obligated, or they feel that the property has more attractive value to it.
Or if you fill out all these.
You know, I don't know. I really don't know. As I was thinking through this weekend, I'm thinking this is an interesting puzzlement for me, because if I represented a seller, because even with the disclaimer here, it doesn't mean that they don't have to fix something that comes up in a home inspection. That's not what it's saying. You know, it's just giving the seller the option. So a seller might not know some of the information above, and they're going to choose to do this one. But bottom line, it shouldn't be both. Okay. And so if you ever receive it and it's got both of them, where the seller has signed both, you need to ask which one are they actually invoking, disclosure or disclaimer. And I don't know if anyone else has any thoughts out there as to which way you would think your client should go. If so, feel free to speak up. Okay. All right, so now in Maryland, we have to give a notice to the buyer and seller of buyer's rights and seller's obligations on the Maryland Single Family Residential Property Condition Disclosure Law, okay? So it's going to enlighten us a little bit on why their laws are like they are. So it's an addendum. Now, it asks for an addendum number. I often find this left blank. If you stack your stuff together, you got a listing agreement, and then you have your first addendum, like your jurisdictional is an addendum, you know, that could be addendum 1. You could give it a number. Where it's going to come into play is in a court of law if they want to know what addendum came first. But I find most often this is just left blank because people don't know what number the addendum is. It really depends on how you load them into your forms, okay? I have a tendency myself to follow the checklist that Maryland gives me and DC gives me, and that's the order which I load the forms in. Okay, so it's dated the day of the contract or the offer, buyer and seller of the property. Okay, note, this notice does not apply to the initial sale of a single family residence which has never been occupied. So this is back up to that same language, okay? I'm not going to reread it, but remember the exempt paragraph. So if someone's using the exemptions, they don't have to do the document we just went over. Therefore, they don't have to do this document as well, okay? Section 10-702 of the Real Estate Articles Annotated Code of Maryland requires that a seller of a single family resident, the property delivers to each buyer on or before entering into a sales contract on a form published and prepared by the Real Estate Commission, either a written property condition disclosure statement listing all defects, including latent defects, or information of which the seller has actual knowledge of. So I think that's one of the areas that hang people up is the word defect. When the first one, the disclosure, it's not just necessarily the defects, it's just information about the property. And I can see where it might be nice to know from a buyer's standpoint what is on the property and all the information about a septic system going into it, or all that information. But again, the seller has to fill it out in its entirety. They just can't pick and choose. So once they start filling it out, they need to NA it where it doesn't apply to them, but they need to complete it because they've started filling it out. And that's what I was telling Rebecca. I almost always get these where the first section's filled out, but it's almost never complete. So I have to go back to the listing agent and ask them to, please complete such and such sections, especially if it says there's a septic system and the seller has completely bypassed that section. So they have to say, is it defective or not, once they start filling that out, okay? So, so written property condition disclosure, filling out the defects, water and sewer systems. So this is just reiterating for the buyer. So this is a notice to the buyer, what the seller is going to, what we just went over, okay? This is what the seller is going to attest to. Or they're going to do a written disclosure statement, okay? Which except for latent defect that they have knowledge of, the seller is making no representation of what could or could not be wrong with the house, and they're selling it as is, okay? At the time of the disclosure, a disclaimer statement is delivered to you, the buyer. You are required to date and sign a written acknowledgement of the receipt of the disclosure or disclaimer statement, which shall be included in or attached to the sales contract. So that was the document we discussed a moment ago. They're either going to sign the disclosure or the disclaimer, but not both parts, because they actually contradict each other, okay? Section 10-702 provides that the buyer who receives the disclosure or disclaimer statement on or before entering into a sales contract of sale does not have the right to rescind the contract based upon the information contained in the disclosure or disclaimer statement. So it's not a contingency that once the buyer acknowledged that they've received it, because it's the disclosure, they can't then say, oh, I don't like what it says about the septic, I want out of the deal. They can't do that, okay? Because it's not a contingency. You are hereby notified that in certain circumstances, you have the right to rescind your contract with the seller if the seller fails to deliver to you the written property condition disclosure or disclaimer statement. Section 10-702 provides that a buyer who does not receive the disclosure or disclaimer statement on or before entering into the sales contract has the unconditional right upon written notice to the seller or seller's agent. So let's say you make an offer and they don't have the disclosures online, but the listing agent says, oh, just send your offer over, we'll get the disclosures back to you, okay? And the seller signs your offer, and then they send the disclosures back to you. Well, you did not receive them on or before, so you have the right to then void and get out of the offer because you didn't have the time to see them ahead of time, okay? Does that make sense? Okay, to the immediate return of any deposits made on the account of the contract. So normally you would not have put EMD until you're fully ratified, and you never ratify a deal till you have all your disclosures. Don't ever do that. Just don't do it. It's not good contractual practice. Okay. And nor do you ever have your buyer sign a disclosure statement that the seller has not themselves completed. Never let a listing agent say to you, oh, just have your client sign it and my client will fill it out. No, 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 no. And I can tell you, I've been told that numerous times by listing agents, and I'm just dumbfounded every time. I'm always like, what? You know, so just don't do it. And I'm not being prejudiced against Maryland or DC, but I do find that happens more in Maryland than the other two. And I don't know why it is. I guess because it's so cumbersome or something. Your right to rescind the contract under section 10702 terminates if not exercised before making a written application to a lender for a mortgage loan. So again, if you haven't gotten those disclosures and you really want the house, but you've signed the offer and the seller signed the offer and you still haven't got the disclosures, if you make an application to the lender, then what does it say here? Your right to rescind is terminated. You cannot rescind. That means you're accepting it the way it is without those disclosures. If the lender discloses in writing at or before the time of application is made that the right to rescind terminates or submission of the application or within 5 days following receipt of the written disclosure from a lender who has received your application for a mortgage loan. If the lender disclosure states that your right to rescind terminates at the end of the 5-day period, okay? Your rights as a buyer under sections 10702 may not be waived in the contract, and any attempt waived to waive or is voided. That means the seller or a broker or someone cannot give you a piece of paper where you as a buyer are going to waive your rights to those disclosures. You can't do it. You can't waive them away. Your rights as a buyer to terminate the contract under 1072 is waived conclusively if not exercised before closing or occupying the property, whichever occurs first, in the event of a sale, or occupancy in the event the lease with the option to purchase. So your rights as a buyer under the section may not be waived in the contract, and any attempt to waiver is voided. Your rights as a buyer to terminate the contract are waived conclusively if not exercised before. So if you go ahead and occupy it, then your rights have been waived, okay? Even though you're not allowed to waive your rights away, if you go ahead and follow through on the deal and occupy the property, then they are therefore waived, and then you have no leg to stand on in court, okay? The information contained in the property condition disclosure statement is a representation of the seller and not the representation of the real estate broker or salesperson, if any. A disclosure by the seller is not a substitute for an inspection by an independent professional home inspection company. You should consider obtaining such an inspection. The information contained in a disclosure statement by the seller is not a warranty by the seller as to the condition of the property of which condition the seller has no actual knowledge or other condition, including latent defects in which the seller has no actual knowledge. The seller is not required to undertake or provide an independent investigation or inspection of the property in order to make the disclosures. So you as a listing agent, you're ensuring your client that in order to, if they choose to answer the disclosures, they don't have to have a home inspector come through. It's based on their knowledge only, okay? If they know the faucet leaks in the master bath, get it fixed, and that way they don't have to declare that there's a leak. But if they don't get it fixed, then they have to declare that there's a leak. You may wish to obtain professional advice about the property or obtain an inspection of the property, okay? Here again, the agents are also being required to sign this buyer's acknowledgement. Okay, so the ages, if the onus is on them, okay? Regulation easements and assessments, REA disclosure and addendum required for all listing agreements and sales contracts in Montgomery County. Woohoo! It's probably the document I dislike the most. It's the one that's usually missing. It's the one that's usually not filled out. It's the one I'm usually always having to call to get information on. Or the attachments that go along with it that if you guys remembered, because in your checklist, which is on, in your book on page 36, copy of the tax bill, estimated property tax, the recorded subdivision plat and utility and cost usage history. Even though there's a form for the utility, they can use their form or not, but 3 of the items, it says NA, but that means there's no pre-printed form. They're still required because the word required is sitting there next to them. And that's usually what's missing, are those items, okay? So notice to seller and buyer, this disclosure or addendum added to be completed by the seller shall be available to prospective buyers prior to making a purchase offer and will become part of the sales contract for the sale of the property. The information contained herein is the representation of the seller, not the agent. The content in this form is not all-inclusive, and the paragraph headings of this agreement are for convenience and reference only, and in no way define or limit the intent, rights, or obligations of the parties. Please be advised that the website and addresses, personnel, and telephone numbers do not change, and GCAR cannot confirm, do change. I don't know where I got the not from. I was like, well, that doesn't make sense. Do change, and GCAR cannot confirm the accuracy of the information contained in this form. When in doubt regarding the provisions or applicability of the regulation, easement, or assessment information should be verified with the appropriate government agency. Further information may be obtained by contacting staff and websites of appropriate authorities. Okay. So it's giving you some information here. They update it when they know that there's a change. So the Montgomery County government, the main telephone line, the planning commissioner, their website. So this is where you're going to go, your client's going to go, not you. Your client's going to go to download some of the documents they may need. Okay. Disclosure and disclaimer statement. A property owner may be exempt from the Maryland Residential Disclosure Act as defined by the Residential Property Disclosure and Disclaimer Statement, which we've just gone over all that. Is the seller exempt from the yes or no? So you've already, in sequential order, you've already had your client go through all this. So now you know if they're exempt or not, right? Your client should know if they're exempt or not. Okay, you should be working with your client to fill this information out. And I can see why so many of them aren't completed, because if agents are charging such low fees and cutting the commissions, they're not spending the time to do this right. And that's where we need to set ourselves apart. Smoke detectors. Maryland law requires that all smoke alarms be less than 10 years from the date of manufacturer. Also, battery-only operated smoke alarms must be sealed units incorporating a silent hush button and long life batteries. Pursuant to the Montgomery County Code, the seller is required to have working smoke alarms. Requirements for the location of the alarms may vary according to the year the property was constructed. For a matrix of the requirements, so you send your seller here, or you're sitting with your seller, you guys go to that website, you look up the requirements for their location, the age of their home, and where they're required to be. In addition, Maryland law requires the following disclosures. This residential dwelling unit contains alternate current AC electric service in the event the power outage or alternating current AC power smoke detectors will not provide an alarm. Therefore, the buyer should obtain a dual powered smoke detector or battery operated smoke detector. So if there's a smoke detector that's wired, it also should also have a battery powered backup. So when the power's out, it still functions. Okay. Moderately priced dwelling units. In the property part of the moderately priced dwelling unit program in Montgomery County, the city of Rockville, or the city of Gaithersburg. So is the property located, yes or no? If yes, seller shall indicate a month and year of the initial offering. If initial offering is after March 20th, 1989, the prospective buyer and seller should contract the appropriate jurisdictional agencies to ascertain the legal buying and selling restrictions on the property. So the seller should know if they're part of a program, okay? I personally don't know if the deed has it on there or not, or how they determine, but they would know when they purchased it that it was. And remember, your sellers are filling this out. Radon disclosure. A radon test must be performed on or before the settlement date of a single family home in accordance with the Montgomery County section. A single family home means a single family detached or attached residential building. Single family home does not include a residential unit that is part of a condominium regime or cooperative housing corporation. The seller of a single family home, unless otherwise exempt below, is required to provide the buyer on or before settlement date a copy of the radon test results performed less than 1 year before the settlement date, or permit the buyer to perform a radon test, but regardless, a test must be performed and both seller and buyer must receive a copy of the radon results. If buyer elects not to or fails to perform a radon test, the seller is mandated to perform the test and provide the results to the buyer on or before settlement date. So in Maryland, the seller has to do it unless the buyer is going to do it. So here is one of those situations where a buyer may choose to do it in an offer situation to take some financial pressure off the seller. Now the seller is still obligated to fix any, and all that negotiation becomes part of the radon negotiation, inspection and contingency. So is the seller exempt from radon test disclosure? Yes or no? Okay, now it's going to, and then now for the rest of the story, as Paul Harvey would say, the exemptions. The property is not a single family home. It's said above. If it's a condo or co-op, they're automatically exempt. Transfer is an intra-family transfer under the Maryland. So mom's going to sell it to daughter, therefore it's not required. Sale is by a lender or an affiliate subsidiary lender required. So it's a foreclosure, a deed in lieu. It's a tax sale, what they call a sheriff's sale, again, foreclosure, auction. A transfer by the fiduciary in the course of administration, so the deceased person. Transfer of the home to be converted to something other than what it is, so it's going to be demolition. Property is located in the town of Barnesville, town of Kingstown, town of Poolsville, or the city of Rockville, so they are exempt. Okay. If not exempt above, a copy of the radon test is or is not attached. If seller will provide the results of the radon test in accordance with the Montgomery County Code, unless the contract includes a radon contingency. So if you're going to have your seller go ahead and do the radon prior to going on the market, then you would just load that in the document section. So online, so they see that the radon's been done and what the radon level is. Now, again, if your seller does the radon and it comes back high, they have it remediated, then they're going to declare that it's been remediated, it's going to be retested, and then those test results are going to be provided. Okay.
Did you say how old is the septic?
A year, within a year? I think that's what it said, within a year, right? Perform less than 1 year from settlement date. Yeah, less than 1 year from settlement date. So in paragraph 4. So if you're in a buyer's market, you might not want your, your seller may not want to do it till you get a contract type thing. So they don't do it twice. So the availability of water and or sewer services. Existing water and sewer services refers to the seller's water bills or contact. So you're going to refer to their water bills. You're going to contact the service, the WSSC or the City of Rockville, well and septic locations, contact the Department of Permitting Services, well and septic, or visit the websites. For well or septic field locations, visit the website. Or for homes built before 1978, request as a build drawing in person using the DPS septic system location application form. Homes built prior to 1960 may be filled and may be filed on microfiche, and if outside a subdivision, the name of the original owner may be required. An original owner's name may be found among the land records at the courthouse. Allow 2 weeks for the as-built drawing, okay? So again, remember, it's your seller who's obligated to gather this information. So if there's a well and septic, they have to gather certain information. Categories: to confirm service area category, contact Montgomery County, okay? So water, is the property connected to public water, yes or no? If no, is it approved? If no, has it been approved to be connected to public water? If not, the source of the potable water for the property is. So is it a well? Okay, is that the source of the potable water? Potable meaning drinking, okay? I'm gonna sneeze. Excuse me. Seller, so I'm sorry, sewer. And is the property connected to public sewer, yes or no? If no, answer the following questions. Has it been approved to be connected to the public sewer, yes or no? Or you don't know. Has an individual sewage disposal system, has it been constructed, yes or no? Has it been approved? Has it been disapproved? If no, explain. Categories: the water and sewer services area categories are categories that currently apply to the property is or are not known. This category affects the availability of the water and sewer services as follows. So remember, you're going to back up to the categories here, and they need to go to those websites to see what category they fall in, okay? Recommendations and pending amendments if known. The application master plan contains the following recommendations regarding water and services to the property. Okay, the status of the pending water and sewer comprehensive plan addendums, amendments of the property area category changes that would apply to the property if there's any. So it could be that a property may have well, but now they have access to public. So there's plans that says it's public available, but maybe the homeowner has chosen not to connect for cost or the fact that they like being on their own water system, okay? Well, and individual sewage systems. When a buyer of real estate property that is located in a subdivision of which an individual sewage disposal system has been or will be installed, receives a copy of the recorded subdivision plot, the buyer must confirm in writing by signing this plat that the buyer has received and reviewed the plat, including any restrictions on the location of initial and reserve wells individual sewage disposal systems, and the buildings to be served by any individual sewage disposal system. So the buyer is given the plat, which shows where the wells and the septic field is, and they have to understand and know that. You know, you don't want to build a shed on top of your septic field, okay? So by signing below, the buyer acknowledges that prior to signing the contract, the seller has provided the information referenced above or has informed the buyer that the seller does not know the information referenced above. The buyer further understands that to stay informed of future changes in county and municipal and water sewer plans, the buyer should consult the county planning board or any appropriate municipal planning for water and sewer agencies. Okay, City of Tacoma Park. If the property is located in the Tacoma Park, the Tacoma Park sales disclosure must be attached, okay? Homeowners and condominium cooperative associations. The property is located in a homeowners association or a condo association, okay? Or a, refer to the GCAR Condo Disclosure Resale Addendum Act, okay? So is it or is it not, and what's the name of it, okay? Underground storage tanks, they know or they don't know. Deferred water assessment. Washington Suburban Sanitary Commission, the WSSC, or the local jurisdiction, are there any potential front footage benefit charges, deferred water and sewer charge for which the buyer may become liable, which do not appear on the attached property tax bill? So in Maryland, you might have, when you're studying Maryland, those of you who've already taken the Maryland test, all the water rights we had to study, all the riparian rights. So frontage is how many feet there is. So there might be extra taxes, okay? So the seller will know if they're paying these fees or anything. So that has to be declared. Private utility companies, are there any deferred water or sewer charges paid to a private utility company which does not appear on the attached property tax bills? So, you know, there's some private company that they're paying stuff to do certain things, okay? Effective October 1st, 2016, notice required by Maryland law regarding deferred water and sewer charges. This property is subject to a fee or assessment that purports to cover or defray the cost of installing or maintaining during construction all or part of the public water or wastewater facilities constructed by the developer. The fee or assessment is blank, payable annually, blank, until blank. Okay, again, your seller is going to know if they're paying these deferred water fees, okay? Deferred meaning it didn't take place up front, they're deferred it later, or it was deferred and now they're in the mix of paying for it. If a seller is subject to this disclosure fails to comply with the provisions of this section, prior to settlement, buyer shall have the right to rescind the contract and to receive full refund of all deposits paid on account of the contract, but the right of rescission shall terminate 5 days after the seller provides the buyer with the notice of compliance, okay? The following statement, the seller shall be liable to the buyer for the full amount of any open lien or assessment. So in the deferment situation, if the seller hasn't paid it yet, and it's been deferred, but it's been due, and there's a lien, the seller is liable for that lien, okay? It's going to show up. Special protection areas. The spa. It's not a spa. Refer to the website for the explanation of the spa legislation and a map detailing protected areas to determine if a particular property which is located close to a protected area as designated on the map is located within boundaries of the spa. Is this property located in an area designed under the spa? Yes or no? If yes, special water quality measures and certain restrictions and land uses and impervious surfaces may apply. So you may have restrictions to what you can do to land if you're in one of those areas. Existing water resources or other environmental features directly relating to the water resources are high quality or are unusually sensitive. So ecosystems and stuff like that. Proposed land use would threaten the quality or preservation of those resources or features in the absence of special water quality protection measures, which are closely coordinated with the appropriate land use controls, as a spa may be designated in a land use plan, a comprehensive water supply and sewer system plan, a watershed plan, a resolution adoption after at least 15 days notice of a public hearing. The buyer acknowledges by citing this disclosure that the seller has disclosed to the buyer the information contained in section A and B before the buyer executed a contract, okay, for the above referenced property. Now, so even here, they're asking up front yes or no. So the buyer still signs because they're asking yes or no, okay? This is one of the sections that I often find that is missing as well. When I get this, they just don't answer it yes or no. They have to answer it, okay? They, meaning the seller, has to answer it. So if you ever get a disclosure, you need to go back to the listing agent and say, and I send them an email and I say, please have your client complete paragraph 10, whatever there are, and ask them to send it back to us, okay? Property taxes. Each property in Montgomery County is assessed for annual real estate taxes based on several different components. A copy of the tax bill will reflect which categories and components are applicable to this property, including whether the property is located in a municipality, a special taxing district, a development district, a proposed development district, and or whether this property is subject to a special area tax or any WSSC front fee benefit charges. Remember, that's about the water. Definitions and explanations of each of these categories can be obtained at the Montgomery County Department of Finance website in the frequently asked questions. So Maryland asks a lot of the sellers, but they at least give them the resources to go to, right? So then a current tax bill. In accordance with the Montgomery County Code section 40-12C, the sellers must attach here to a copy of the current tax property bill for this property. A copy of the tax bill can be found, okay? The estimated property tax and non-tax charges, in addition to the sellers, are required to provide potential buyers with the estimated property tax and non-tax charges for the first full fiscal year of ownership. There again, right there it says, the buyer acknowledges receipt of both tax disclosures. Now, do not have your buyer initial this if they didn't get it, okay? So if the seller hasn't given it to them and you're whipping yourself through DocuSign, you got to be careful as the buyer's agent. If they're not in the package received, you don't want your buyer to initial it. They have to be given those documents, okay? And this is, one of the things I know Shannon probably is going to give Shannon gray hairs over stuff like this, because not only is the listing agent not doing their due diligence, then as buyer's agents, we're anxious to get a deal, we're anxious to get a property for our client, and we're whipping through this stuff and we're not realizing, oh, there was no tax bills in there, but the buyer has acknowledged that there was, okay? Because you as the agent put their initials there in DocuSign, okay? Your buyer should say, where is the tax bill? Okay, but as we all know, most people are not reading what they're signing. Unfortunately, as a paralegal for so many years, that gives me chills that people sign stuff, but we all do it. We sign everything on Apple. We agree to all their disclosures and we don't read it, right? So unfortunately, that's where we are. Okay, a development of district disclosure, notice to special tax or assessment. A development district is a special taxing district in which owners of properties pay an additional tax or assessment in order to pay for public improvements within the district. Typically, the development district special tax will increase approximately 2% each July 1st. For information, please contact Montgomery County Department of Financing. FAQs regarding development districts can be reviewed at. So if you're not sure, your sellers should know. But if you're not sure, and you as agents, when you have some downtime, go look at some of these sites and see what they are, so you're familiar with them if you're going to work in Maryland. Now, full disclosure for you guys, I have not bought and sold any property with anyone in Maryland, but I've written a lot of Maryland contracts, like I've told you guys, and I've received on the end to review contracts written on listings for other agents, and have for many years. So that's why I hold the license, so that I can do that. And living out in Culpeper, I would rather just refer it to somebody than to drive over. But, anyway, the property is located in an existing development district, yes or no. The property is located in a proposed development district, yes or no. The property is not located. So again, these have to be answered, okay? Whatever it is, they have to be answered. Tax benefit program. There's forest conservation, agricultural programs, and other tax programs. Do any of these apply? They need to be answered. Recorded subdivision plat. Here's another section that I find as a listing agent, working on the listing agent side, working for the seller and the listing agent, when we get documents from the buyer and we've provided all the information to them, this is a section that I find that they may have the buyer's initials here, but they don't check A, B, or C, okay? So plans are available at the Judicial Center, room 218, at the address in Rockville. In order to obtain a plat, you will be required to supply the lot, block, section, subdivision as applicable for the property. Plats are also available online at, which is easier than going to the property, going to the address there. Buyers shall check one of the following. It says right there, buyers shall check one of the following: unimproved lot or new construction. If the property is an unimproved lot, piece of land, or newly constructed housing being sold for the first time, the buyer shall be provided a copy of the recorded subdivision plat prior to entering into the contract. Buyer hereby acknowledges receipt of the copy of the recorded subdivision plat. Or buyer acknowledges receipt if the property is not an unimproved lot or newly constructed house, i.e. resale. The buyer may, in writing, waive receipt of a copy of such plat at the time of the execution of the contract, but shall, prior to the time of settlement, be provided with a copy of the subdivision plat. The subdivision plat is not intended as a substitute for the examination of title and does not show every restriction and easement. Buyer hereby acknowledges receipt of the recorded subdivision plat. Or resale waived receipt. For resale purposes only, buyer hereby waives receipt of a copy of such plat at the time of execution of contract, but shall, prior to the time of settlement, be provided with a copy of the subdivision plat. Okay. Again, they need to choose one, and most likely it's going to be B or C, but they have to be provided the plat. It could be that the seller just hasn't gone out to get the plat and you're in a hurry to get the contract done and it wasn't part of the download. So you can waive, you can choose it, but this still has to be provided. So you as the buyer's agent need to stay on top of it and make sure you get that from the listing agent, okay? Agricultural reserve disclosure notice. The property is or is not subject to agricultural reserve disclosure notice requirements. These disclosures are contained in the GCAR agricultural zone disclosure notice, which must be provided to the potential buyers prior to entering into a contract for the purchase or sale of property that has subject to agricultural reserve disclosure requirement. Okay, again, what is it zoned for? Is it agricultural? Is it reserved? What is it? They go to the website. Does it apply to them or not? Notice concerning conservation easements. I'm sorry, hang on one second. I've got a friend who's sick in the hospital and they're just sending me a notice. Okay. Okay. Notice concerning conservation easements. The property is or is not subject to a conservation easement. So is there something conservation for some type of animal or water area or ecosystem? Is their home butting up against that? They'll know, but if not, they can go to the website. Ground rent, this property is or is not subject to ground rent. Ground rent, the easiest thing to think about ground rent would be like a co-op is usually on ground rent, but trailer parks, usually they're renting the land and they bring their own double wide in, for example, in a trailer park area. So there's ground rent involved. So someone could be selling their trailer for $100,000, but they also may have to pay $3,000 a month for the land that it sits on, depending on where it's located. In this area, I know Manassas has an area like that. You don't see them a whole lot anymore.
They're actually a lot in Baltimore because when we first like started building in this city, there were still like lords and royalty that owned the land and
Uh-huh.
they had to pay rent to them, but they put them on like 200-year leases, and so they're still paying them off now because we're just in 2020 and most of them are ending in the next 50 years.
So Rebecca is stating, like in Maryland and stuff, because the lords and the royalty that own the land, there is land ground rent there. And yes, more common in Maryland than in Virginia. Yeah. You can tell by the Maryland flag. Yeah. Oh, cool. All right. Historic preservation. So is it a historical preservation? Then they need to reach out to those entities and find out about it. Has the property been designated historical, yes or no? So they need to answer those questions. And they're going to know, they should know what their property is. They've been living there. But then there's all these websites that let them go to verify for sure. Okay. But then again, remember, if you're an executor, someone who's passed away, you're not filling this information out because you're not required to know. You're exempt. Remember, you're exempt from the disclosures. Okay, Maryland forced conservation laws. Does it apply or not? Airports and heliports. The following list of airports and heliports includes those in Montgomery County and surrounding areas. So here you go. Maryland requires you to let them know where they are. So they provide you this map. You don't have to do the work for yourself. And it tells you where everything is. So if your client wants to live in Maryland but does not want to be near any airspace, then there you go. There's a few places out there. But for the most part, we're really overlapped everywhere. Okay. And it continues on and it brings even Virginia's in. Okay. Because they're going to fly over that's airspace. Okay. Then you've got your energy efficient disclosure notice and the usage history. So has the home been owner occupied for the immediate prior 12 months? Owner occupied, yes or no? If the property has been owner occupied for the last 12 months, seller must provide copies of the electric, gas, and home heating oil bills or cost and usage history. So that's the documents on the document that's on page 36, the utility history, document number 932. It's just a spreadsheet that they can fill in, or they have to provide all their bills. So it's easier for them to, fill out the spreadsheet personally, I think. And then they have to disclose what the utility costs are. Okay? Aren't you guys having fun? Okay, lead-based paint federal disclosure. I'm not going to read this. We all know what it's about. The language is pretty similar. If it's built before 1978, if it's built in 1978, then they don't have to fill it out. If it's built before 1978. But here, unlike Virginia, the questions are asked a little bit different at the beginning. Are there any parts of the house? So that's where someone may have torn down most of the house but left a foundation wall. Down here, it's laid out a bit different than it is on the Virginia one, but basically it's the same. Does the seller have knowledge? Does the seller not have knowledge? Are there reports available? Are there no reports available? The buyer. Did the buyer get the lead-based warning statement above? Okay, it's right here. It's on this document. Buyer has read paragraph B. Okay. So the buyer, which is over here, paragraph B. Okay. Buyer has received the pamphlet for your protection. And then the buyer is going to do a lead-based paint or they're going to waive it. Okay. And again, now, unlike Virginia, here is only the listing agent who initials. Okay, but it's the buyer's agent who signs as well as the listing agent. But both agents do not initial. Okay, Maryland lead-based paint prevention program. So this was federal above. Okay, remember this one's federal. And now we have to do Maryland. You have to do both. A little bit redundant, laid out differently, but you have to do it nonetheless. So property address. So here the property is or is not registered for the Maryland program. Okay, so under the Maryland lead-based poisoning prevention program, any leased residential dwelling constructed prior to 1978 is required to be registered with the Maryland Department of Environmental detailed information regarding. So if it's built before 1978, the seller has to confirm that yes, they are or not registered. If they're not, they better get registered because it says they're required to be registered. Okay, if the property has been constructed before 1978, buyer intends to lease the property. The buyer, oh shoot, I didn't mean to do that. Never mind. Okay, so if they're going to lease the property out, the buyer has to comply by the laws, right? And then to make sure that the property is registered. It was built before 1978. So if the property is registered under the Maryland Protection and Program indicated above, the seller further discloses to the buyer that an event as defined under the Maryland Protection, including but not limited to the notice of existence of lead-based paint hazards or notice of elevated lead levels from the tenant or state or local municipal health agencies, seller to initial applicable. Seller has or has not occurred. So if someone has gotten sick from lead-based paint and the seller knows about it, they have to let you know. If such event has occurred, the seller who initials the applicable line will or will not perform the required treatment. So if there's lead-based paint that's made someone sick, the seller will or will not take care of cleaning out the lead-based paint. Buyer acknowledges that the buyer initials that they have read and understand the above paragraphs. And then they're certifying the accuracy of the statement. Buyer and seller and the agents all sign. Okay. All right, so that, guys, is in a nutshell that is what the listing agreement encompasses for Maryland. Okay. Anyone have any questions? All right. Sorry, my head is hurting me. Let me ask you, let me see how many people are online here. There's me and 5 of you guys. Do you guys want to continue on? It's 2:00, or we'll just pick back up on contracts on next Monday, putting it all together. Any votes either way? Anyone? Okay, next Monday.
Debbie, if you're not feeling well, let's go to next Monday.
If you don't mind, yeah. I have a sinus infection and it's, my eyes are, I'm getting to the point I
Yeah.
can hardly read right now.
No, that's okay.
But,
You've done a great job. Thank you.
Guys, I'm not reading the chats. I don't see them pop up because the way my screen is set. So if you guys have any questions or don't know what I'm saying, just please, just yell out. I don't mind being interrupted with questions or anything, but I appreciate your forbearance today. And my voice has held out this long, so that's good. So we'll reconvene next Monday at, it should always be the same sign on at noon. And we'll go through we'll look back at any differences with DC with the listing, and then we'll move into contracts. Okay?
Thanks,
Thank you all
Debbie.
very much.
Thank you. Thank you, Debbie.
Thank you.
Take care.
Thank you.